Hello and welcome to this short video on civil courts, the track system and appeals in civil cases. So on the AQA specification, this is in paper 2, the English legal system, you need a basic understanding of civil courts, and you need a little bit more than is in this video because you need to be able to compare them to other forms of dispute resolution such as negotiation and mediation, which we're not going to cover in this video. So we're just going to look at the civil courts cases heard at first instance, the track system and appeals. So the civil courts here, all issues of civil law that aren't dealt with by a tribunal. So if you've got a case like employment or immigration or social security, then they have to be heard by the relevant tribunal. So really here we're talking about contract and negligence cases. And the courts of first instance for those sorts of claims are the county and High Court. This just means it's where they're heard for the first time. And the appeal courts are the High Court, the Court of Appeal and the Supreme Court. So we're going to have a look at how you decide where cases will be heard, in which court they'll be heard. And in civil law, this is dealt with by the track system, and it's different to criminal law, where cases are divided according to severity, summary either way or indictable, and then that determines whether you're in the magistrate's court or the Crown Court. In civil cases, we have 4 tracks. The small claims track is for claims up to £10,000 or 1.5 for personal injury. The fast track is 10 to 25, again 1.5 to 25 for personal injury claims. The intermediate track is for claims worth £25,000 to £100,000, and the multi-track is for claims over £1,000 or for complex claims over £25,000. So we'll have a quick look at the small claims track. The small claims court is part of the county court, and the claim would be heard there by a district judge. The judge will actually be quite involved and ask questions of the parties, and it will be a shorter hearing, and also it will be more informal than one of the other higher tracks. The parties would usually be unrepresented. That means they wouldn't have a lawyer, and there are limited costs that can be awarded against a party. The fast track is heard in the county court as well, but it's by a district or circuit judge. It's a little bit more formal than the small claims, but the hearing will be limited to a day and there are fixed recoverable costs. And on the intermediate track, this will be heard in the county court by a circuit judge. It's a little bit more serious. These are higher value cases, 25 to 100,000. The hearing will be limited to 3 days and each party can only call 2 experts. And again, there will be fixed recoverable costs on the intermediate track. And then on the multi-track, this is heard in the High Court. So this would be a High Court judge hearing the case in the High Court. And there is an emphasis on case management, which means they will set a strict timetable for things like exchange of documents. And this will be with a view to trying to encourage the parties to exchange their documents early and then to settle the claim and to encourage use of alternative dispute resolution. There'll be a strict timetable that, as I said, encourages this to happen. So it's a more formal process. We're now going to have a look at the last thing that I wanted to cover, which is where somebody is unhappy with the decision and they want to bring an appeal. And the system here is different from criminal appeals, which go from court to court. In civil appeals, the route of appeal depends on whether the case has been heard in the county or High Court and the level of judge that heard the case at first instance. So in all cases for appeals, the appeal must have a real prospect of success, and you need permission either from the lower court or from the court you are appealing to. So let's have a look at the county court first. So this is going to cover your small claims, fast and intermediate. And there are 2 possibilities. You'll either have your case heard by a district judge or by a circuit judge. If it was by a district judge, then the appeal is to a circuit judge. And if it was originally heard by a circuit judge, then you appeal to a High Court judge. From both of those, you can have a second appeal. And that is only where there's an important point of principle to be decided and you get permission either from the lower or the appeal court. And in that case, for both of these, the appeal will go to the Court of Appeal Civil Division. So that's appeal routes from the county court, but we've also got to look at appeal routes from the High Court, and this is for your multi-track claims. This is more straightforward as it doesn't depend on the judge. It will go to the Court of Appeal Civil Division for the first appeal, and then the second appeal would go to the Supreme Court. Again, it has to be a point of law of public importance, and you need permission. There is the possibility of a leapfrog appeal, which is where a case would go direct from the High Court to the Supreme Court, leapfrogging over the Court of Appeal. And this has to be on a point of law of public importance, and again, you need permission, or it can be sometimes when there is an urgent decision that's needed and you go straight to the Supreme Court for that. Okay, so where are we going to find this in the exam? Well, you probably could find it in a multiple choice question, but you may also be asked to explain for 5 marks as a question 6 in the AQA exam, something to do with civil courts, either the system, civil court system, how cases are allocated, or the system of appeals for civil cases. And this is different to the assessed questions, which are worth 7 marks, which are evaluation based and analysis. So explaining is all AO1 for the 5 marks. It's about your knowledge of the law. So let's have a look at the 3 possibilities. Explaining the civil court system. You would have to describe the courts of first instance, which are the county or high court. The county court includes small claims. Then you could explain that the court depends on the track that you're on. So small claims, fast and intermediate track claims would all be in the county court, and the multi-track would be in the high court, and then you could set out the limits. And appeals would be heard by the Court of Appeal Civil Division and the Supreme Court. Now, the second type of question you might get is to explain how cases are allocated in the civil system. And then you would set out the different tracks with the limits, the court they're heard in, and the judge that hears them. So there's small claims. Fast track is in the county and heard by a district or circuit judge. Intermediate, heard in the county by a circuit judge. And lastly, multi-track above 100,000, or in complex cases over 25,000, including cases where the police are being taken to court under the Human Rights Act. Then these are heard by a High Court judge in the High Court. And lastly, if you had to talk about civil appeals and explain how the appeals work in the civil system, you need to know that the appeal route will depend on whether the case was heard in the county or the High Court, and you need to know the level of judge that heard the case at first instance. So for the small, fast and intermediate tracks, those will have been heard in the county court, so the route will depend whether it was heard by a district judge, which will go to a circuit, or whether it was heard by a circuit judge, which will go to a High Court. All appeals on the multi-track go to the Court of Appeal, and we noted that there's a second appeal to the Supreme Court, and you can also make a leapfrog appeal to the Supreme Court as long as you get permission, and it's a point of law of public importance. So I hope that that's been useful. Summary of civil courts, the track system, and appeals in civil cases. Thank you very much.